Ma'am, should I begin?
Princy ma'am.
Yes.
Good morning, everyone. I am Ketayun Mistry, the General Secretary of the Student Council at Government Law College, Mumbai, and I shall be your host for today. I would like to welcome you all to the 5th lecture of the National Guest Lecture Series on the very important topic of emerging issues in constitutionalism with relation to climate change, business, and the vulnerable. I would like to welcome our keynote speaker for today, Professor Dr. Shashikala Guppa, who is the Director of Symbiosis Law School, Pune, and the Dean, Faculty of Law, Symbiosis International University, Pune. We are honored by your presence, ma'am. We also have with us our principal, Dr. Asmeta Vaidya, and we're very grateful to have you. We also have our senior professors and other faculty members, along with multiple students today. The National Guest Lecture Series has been organized by Government Law College, Mumbai under the leitmotif of Azadi 75. Azadi 75 is the celebration of 75 years of our Constituent Assembly. We at GLC Mumbai aim to have 75 such events to commemorate this special occasion. Before we proceed today, we shall play the Saraswati Vandana to request Saraswati Ma to shower us with her blessings. I would like to take this opportunity to today introduce our Honorable Principal, Dr. Asmeta Vaidya, an academician, an educator, a social activist, and an able administrator whose vast experience in the field of academia and social service has placed her at the front lines of various social issues, effecting reforms and empowering people. Dr. Vaidya is also the recipient of several awards, such as the Tejaswini Award, the Nation Builder Award, and the Superwoman 2020 Award. She has served as the head of Department of Law at NMD College of Arts, Commerce, Law and Management in Gondia, and has also acted as the principal of Gokhale Education Society's N.B. Thakur College of Law, Nashik, before finally taking up responsibility as the principal of Government Law College, Mumbai. As an accomplished leader, Dr. Vaidya has won over the hearts of all students at GLC with her enthusiasm and efforts to introduce a variety of new programs and courses. Ma'am, I request you to speak a few words on this occasion today.
Thank you, Ketan. Ma Saraswati Lavandan. Good morning to all. Today is a Human Rights Day. This year, the theme of Human Rights Day is equality, reducing inequalities, advancing human rights. The theme relates to equality, and Article 1 of UDHR says all human beings are born free and equal in dignity and rights. Keeping this in mind, today we decided to have a lecture on emerging issues in constitutionalism with relation to climate change, business, and vulnerable. We have with us Professor Dr. Shashikala Guppa Madam, who is a fine blend of academics and administration. She is the director, Symbiosis Law School, and Dean Faculty of Law, Symbiosis International University, Pune. Madam, on behalf of GLC, family, staff, and students, we heartily welcome you. Climate change has an intense impact on a wide range of human rights and of constitutional rights, such as the right to life, self-determination, food, health, water and sanitation, and housing. The constitutional and human rights framework requires the global efforts to mitigate and climate change be guided by relevant human rights norms and principles, including the right to participation and information, transparency, accountability, equity, and non-discrimination. Inevitably, climate change is a human rights issue and is of constitutional concern, and any solution cannot be devoid of the constitutional rights framework. Climate change litigation provides a tool that can be used to shape climate policy and to seek redress from climate-related injuries. Climate change litigation can be brought within the ambit of various legislative frameworks, such as international law, constitutional provisions, statutes, and common law. Secondly, the Constitution of India guaranteed to all the people of India the civil, political, economic, social, and cultural rights for their realization by all sections of politics without any kind of discrimination. However, due to poverty, customary, and cultural practices prevailing in the country, there have not much opportunity offered to the various groups, which lead to deprive them of being treated equally as the other sections of the society. The concept of vulnerable group is gaining momentum. Disadvantaged and vulnerable groups include groups of people such as women, children, scheduled caste, scheduled tribes, linguistic minorities, religious minorities, sexual minorities, vulnerability due to disability, vulnerability due to the migration, and vulnerability due to stigma and discrimination, like people living with HIV, AIDS, sexual minorities, etc. In order to expand their rights, the Constitution of India has provided a number of concessions to protect them from exploitation by other groups. And thirdly, the constitutional principles have had bearing on business disputes over bilateral treaties, natural resources, contract enforcement, bankruptcy, and more. Various legal provisions for the companies are drawn from it. Dr. Guppa Madam is going to focus on emerging issues in constitutionalism with relation to climate change, business, and the vulnerables. Madam, as Ketain has already told, this year we are completing 75 years to the establishment of Constituent Assembly. In order to celebrate this, we decided to organize 75 academic programs based on Indian Constitution, like national webinar, national guest lecture series, quizzes, awareness programs, and street plays. In this series of guest lecture, you are welcome. I welcome all again. Thank you. Thank you very much.
Thank you so much, ma'am. As ma'am introduced us, our keynote speaker today and chief guest is Professor Dr. Shashikala Guppa, and I would like to give you a short introduction to her. Dr. Guppa is currently the director of Symbiosis Law School, Pune, and the Dean, Faculty of Law, Symbiosis International University, Pune. She is an accomplished academician, a passionate researcher, Toastmaster, and a Fulbright scholar. Dr. Shashikala Guppa is a recipient of several distinct honors and awards for her contribution in legal education, gender sensitization, and community outreach programs. In recognition of her contributions to Indian legal academia, she was listed in the book 100 Legal Luminaries of India by LexisNexis. Dr. Gupur has recently been conferred with the prestigious annual Kittur Rani Chennamma Award by the Government of Karnataka, India, in 2018 for her work towards the empowerment of women. Dr. Shashikala was the member of the Law Commission of India, Ministry of Law and Justice for Government of India between 2010 and 2012, and is currently a member on the Curriculum Development Committee. She is also a life member at the Indian Law Institute and multiple other journals. She also is a distinguished member today, and this is worthy of mention, of the editorial board for the Cyber Law University International e-Journal. She has 79 research papers, 2 co-authored books, 15 book chapters to her credit. She has also presented more than 339 invited lectures, workshops, and seminars across India, Thailand, US, UK, Ireland, Germany, Australia, Canada, and the UAE. All these things mentioned by me are merely the tip of the iceberg when it comes to Dr. Gupur's achievements. We are extremely honored to have you with us, ma'am, and are excited to hear your thoughts on this topic today. Without further ado, I would like to invite you to kindly begin the lecture. Thank you so much.
Good morning, respected Professor Vaidya, respected dear colleague or former colleague, Dr. Umesh, my dear students, all other invitees, and those who are listening or watching this. A very warm Constitutional Day belated, but a warm Human Rights Day. International Human Rights Day for us when we were growing up was a celebration in watching colorful Tibetans going with their flag, talking about their human rights violation in their 2 mega camps in Karnataka, in Virajpet area and then in North Canara district. International Human Rights Day later on became a very significant day for us as law scholars, because today is the day that is commemorating the very first articulation in the post-World War II context on what are the natural, inalienable rights of all human beings. Recently, we were at Jindal Global Law School's debate where we were talking about global anxieties, and I was talking about the center staging of human rights not being done yet, and how it should be viewed with its multifarious connections, as it was highlighted by Professor Vaidya already. What was told was that by other learned speakers like Susan Karamanian of George Washington University, that today is the time when we witness so many constitutions incorporating these human rights, and this as a kind of evolved objective in different parts of the Constitution. If we look at the Indian context in connecting to today's significance, I would say that Part 3 has incorporated majority of the human rights. To begin with, it was more focused on civil and political rights in the Part 3. But with the judicial innovation, it expanded the Article 21 to draw on many unenumerated rights to meaningful human life in right to life. So Part 4 was slowly yielding its territory to Part 3. So in a kind of what we can call as judicial encroachment on Part 4 to make it more enforceable. So it is an encroachment for enforceability that we see in this organically evolving Constitution. Now, I'm not here to discuss with you what a black letter law looks like in terms of case laws, in terms of legislations, in listing them or in connecting them as the Shastrik, means what is there in the book kind of lecture. I'm here to give you a perspective. The perspective that I want to share with you is the perspective on constitutionalism. How do we understand constitutionalism? Majority of our problem is because everyone thinks they are a constitutional scholar. Today, if you look at me also, I'm here on an adventurous journey to talk to you all, because I'm not a person who has worked exclusively in the area of constitution like how Dr. Umesh would have worked. But I am one person who believes that there is a natural need for, or it is a kind of unavoidable necessity to view every law through the prism of constitution, through the prism of not simply written constitution that we have, because a written book does not guarantee enforcement or realization or actualization of all the endowments that we have as citizens and as human beings of this great nation. It is the way in which we guarantee them in our governance, in our social interaction, and in the way in which we believe it as what Dr. D.D. Basu once said, as our living heritage. So are we there, looking at constitution and constitutional guarantees as a living heritage? Because I know that most of you law students, your teachers will tell you what constitution is, when it was adopted, what were the pre-constitutional harbingers of the constitution, whether it is a 1935 act or act before that in 1919, Montemirle and other reforms. I'm not here to talk about that. I'm not here to even enumerate or enlist what part 3 looks like, part 4 looks like, what preamble looks like, because this is something everybody knows in terms of being a sacred document of our legal landscape. For me, constitution is as important as epical texts like Ramayana is or Bhagavad Gita is. Otherwise, I have no meaningfulness in my presence as a person studying law or researching law forever. Or if you're practicing law, all the more it becomes your sacred text, because you're advocating to protect the natural guarantees which we have when we were born as human beings, because these are our inherent rights. These are our inalienable kind of self-actualization opportunities. Have we viewed Constitution that way? In the era of multidisciplinarity and interdisciplinarity, putting human-centric approach to knowledge and learning, how would we view constitutionalism? We have many an inspiration from the judicial innovation. So I'm going to unveil only a few in the limited time that I have. So let me take you through that journey that I have enjoyed all through my academic life in the last 25 years, time and again, revisiting the Constitution. All my life, I have revisited Bhagavad Gita or sacred texts as I was growing up. Every time it revealed a new meaning to me. So also I have revisited Constitution when I shifted from being a student of law and tried to connect my science background and tried to connect my activist life, working with the vulnerable and looking at experiments with justice in terms of outside the court kind of space as much as linking it to the court. So what I have realized is that some of the expressions which came through the Navtej Singh Johar case by Justice Mishra and others expressions in terms of constitutionalism, constitutional morality is very important as we go ahead as a nation and as a humanity. Now, what is that context? If you look at the text of what Justice Mishra at that time said, in terms of constitutionalism, according to him, is the modern political equivalent of Rajadharma, which is a kind of amalgam of philosophy, values, spirituality, and rights, and corresponding duties. Now, he also spoke about something like constitutional morality, but subsequently, or in connection with that, if you look at transformative constitutionalism, which also is spoken about, it is about integrating the idea of the constitutional guarantees into the real democratic context of participation, non-discrimination, being inclusive, and treating everyone equally. Look at our equality doctrine in Article 14, Article 15, Article 16. It's not just equality in terms of sameness. It is equality, creating equality in difference. So the essence of constitutionalism in our country is about protecting such pluralism, protecting such diversity, which neatly aligns with the global compact of human rights, whether you started from the first generation rights of socioeconomic, cultural, and political and civil rights bifurcation, or you've progressed to third generation in terms of rights of the rights of those who were targets of racial discrimination, rights of women, or rights of the indigenous people, and the Yogakarta principles on transgenders. So the whole landscape, which has been traversed globally by different legal systems and different constitutional traditions, have been incorporated, or neatly they have been absorbed into the evolution of human rights. And time and again, constitutions renew themselves in looking at this kind of a transformative constitutionalism, in revisiting idea of participation, non-discrimination, inclusiveness, and equal treatment. More so in Indian context, the kind of justice connotation we have centralized in our preamble, justice as social, economic, and political, that context becomes more important as far as India is concerned in looking at the transformative constitutionalism. We have had wonderful judges who have exhibited the spirit of innovation, youthfulness, wisdom, and a kind of unconventional way of approaching the idea of justice from the point of view of the marginalized, or those who did not have a voice because of many historical reasons. So here, equality in that sense is compensatory kind of approach, where for historical non-participation, you give the opportunity in the newly evolved democracy. We also have idea of equality coming from equal but not same, equal but different. So with the differences, how do you create the common denominator of equality also has been there by talking about special provisions to be made. So we saw this constitutionalism being innovated in judicial interpretation, whether it is in the form of legal aid experiments, or in the form of public interest litigation, or in holding state liable when the state went beyond the mandate which was given to it in the Constitution. So it's a very interesting approach to constitutionalism, in the sense of constitutionalism primarily being about limiting the power, limiting the authority, and limiting that authority in the larger interest of citizens, the liberty. So it's power versus liberty. If students of jurisprudence would go back to their understanding of Hoffieldian scheme, the Hoffieldian scheme looks at rights as liberty, looks at rights as responsibility, rights as power, and if you look at states' right as power, then citizens' right in terms of liberty, and corresponding states' right in a dynamic context, or states' responsibility, where state has a corresponding duty towards the citizen. So understanding the constitutional guarantees in the larger Hoffieldian matrix will make us look at different actors within that. But if you look at the constitutionalism seen in the judicial innovation, one of the very important cases is what the Bombay High Court decided upon the direction of the Supreme Court on granting medical bail to Dr. P. Varavara Rao in February 2021 in the case that we have had, the Koregaon Bhima episode. So here, the courage as well as the independence of understanding of constitutionalism by the judiciary is something that we need to go deeper and see, where it was not a marriage of executive and judiciary, or it was not that judiciary was acting as the parliament's handmaid, which Nani Palkiwala once lamented during emergency in the Keshavananda Bharati case. Today it is very different, where judiciary has always gone in a counter-majoritarian way. Now that is the kind of speaking constitutionalism or living constitutionalism that judiciary has represented. If you look at the other case, which is the Anuradha Bhasin case, which was in the wake of India's annexation of Kashmir, or rather repealing of Article 370, there the Section 144 of Criminal Procedure Code was implemented. So internet was blocked, and all kinds of communication between mainland India and Kashmir were impossible, whereas families were on both sides of the border. So what the Supreme Court said was that internet is one of the basic rights, and it also said that it did not say that immediately make internet available, but it said that this kind of 144 indefinite imposition is not according to the principles of balance, the checks and balances. So it needs to be reviewed. Indefinite kind of extension of 144 CRPC is violative of fundamental rights. Now, what do these show to us? What do these show? If you ask that question, there are a few things. Constitutionalism is a philosophy. It's a philosophy where people are primarily put as the right holders, and there should not be any encroachment in liberty. We have 1215's global historical development, the Magna Carta, which is called as the first charter of human rights, where the governmental power, Crown's power had to be yielding to people's demand of, it was a kind of contract between people and the power, so that there are no incursions made into people's rights. We consider it as the pre-runner or precursor to modern human rights regime. So the whole parliamentary tradition started evolving with that, and the negotiation of power between the people and the power holders was made very clear. So today we have constitutions. Out of all the member states of the United Nations, we may have, out of 190 plus countries, we may have written or unwritten constitution, but constitution is there. Now, wherever we don't see a written constitution, we still see monarchy. Still, the spirit of administration is in the interest of the people. So what we see here is, in some systems, there is a constitution, but those systems have not been able to withstand the emergence of dictatorship, or they have not been able to withstand the insensitivity, apathy, or non-inclusion of the vulnerable. We particularly saw this with the climate change coming in, where we saw that due to the scarcity of water or deprivation of resources to others, or natural disaster due to the climate change, a lot of people being displaced and them migrating to another place or seeking refuge, becoming a kind of environmental refugee, and our laws not being in a position to respond to that, nor the policies looking forward or giving any promise to these people of the life which is guaranteed as a good life under the constitutional guarantees. Therefore, written constitution or unwritten constitution per se is not going to guarantee anything unless the philosophy of constitutionalism is practiced. So this famous theorist, Nouabouze, he is an African origin writer and constitutional scholar. In the 1970s, he spoke about the idea of how the human behavior, or what he calls as human factor, is the greatest threat to vitiate the guarantees of the Constitution. So he says that people will say that it was politically expedient to legislate to, or not to legislate to, a particular segment of vulnerability or needs of climate change. Needs of climate change or environment-centric issues being neglected might happen in the interest of a mega project. It might happen in the interest of some kind of urbanization. So here, human behavior, the behavior of those in power could be justifying it, saying it's politically expedient. Then whose politics? Whose expediency? A constitutionalism philosophy-driven governance expects that one exercises self-restraint. These restraints are there in our constitution under Article 19.2. And if you go to 21 also, it should be according to due process of law and according to the procedure established by law. So we are given these restraints. On the one hand, we are given those liberties. On the other hand, we are given these restraints. Why these restraints? These restraints are to ensure the fair play of rights between many, and between those who hold the power and between those who are subject to this power. And it is mutual accommodation in democratic spirit between those different layers of people who are at different levels of wielding or being subject to power. And the principles of natural justice, that no one shall be tried unheard and no one shall be a judge at his or her own cause, which means that you have to notify, you have to do an open inquiry, and you have to give an opportunity to be heard. Therefore, these kinds of checks and balances are inherent in the Constitution, which come within the purview of constitutionalism. So whenever government goes arbitrary, It is the constitutionalism which gives it the reminder that you are having limited power. Your powers are limited, not to be arbitrary. So limiting the power, simple constitutionalism principle is limiting power, and expanded version is what I told you in terms of self-restraint, fair play, and mutual accommodation with democratic spirit, means consensus building, public opinion are very important, and following principles of natural justice. So the positive connotation of constitutionalism in terms of wielding governmental power is only to one objective, namely welfareist. The negative connotation is you should not exercise your power to the extent of becoming arbitrary. So human factor needs to be limited when constitutionalism as a philosophy is in action. It needs to be protecting diversity. It needs to accommodate those who do not have voice. And here we have the idea of climate change as a kind of larger concern, and the idea of those who do not have a voice, the vulnerable in the society. So we have seen how the democratic spirit of the Constitution or philosophy of the constitutionalism has been activated even in older constitutions of France or US or Canada by means of certain processes. Those processes are the processes which have made these constitutions transformative and socially relevant. First is judicial decision. We all will agree with that. Second is legislation, from time to time, new legislations. Third is amendment. And the fourth is application of the provisions of the Constitution with these philosophies in view. For example, we have such a variety in our India where we have this vulnerability being addressed. For example, Karnataka legislated very recently giving mandatory employment reservation to the transgenders. And we are yet to have legislations to that kind of progressiveness in other parts of India. Or Kerala made a sudden policy change to have medical personnel to be present in the gyms, pursuant to a popular actor in Karnataka succumbing to death because of lack of immediate emergency attention. So this is the way in which the human interest or the well-being or welfare of the people occupies center stage, and thereby what is silent or subtle or not contained in the Constitution, what we call as unenumerated in the Constitution, is breathed life in by means of these adaptations. So on the whole, if I were to cull out the principles, we have multiple writers or scholars writing in this area. We can say separation of powers between judiciary, executive, and legislature, the superior and the subordinate legislations, like we have the legislatures, like the state and the center. So that separation of power doctrine is first principle. Responsible and accountable governance, very important. Government is the second principle. Popular sovereignty, or what we call as democracy, government of the people, for the people, by the people, as Lincoln said in its Gettysburg Address, is the third principle. Fourth principle is rule of law, not rule of people. It's a rule of law. It's a governance according to law. It's wielding power according to law. And the fifth is independent judiciary, which is the sacrosanct principle, also reiterated in the basic structure concept. The sixth is the individual rights, very important, we have in the form of fundamental rights. And then the civilian control of the military, which is very important. So this control of the military is not as a somewhat autonomous entity, but it is in the Constitution that power is given to the president. President is the supreme commander of the armed forces. So these seven principles, which I stated, if you see, not seven, they are, seven principles. If you see deeply, as I have highlighted already, the core in that is Constitution defines the state. It restricts the powers of the state. It defines the powers of the state and it restricts the powers of the state. Article 21 has been an ever-evolving provision, which is putting again citizens' needs in the center in changing times. If you look at Article 21, we adopted 21A. We expanded the principle of life to include right to good health, right to good environment, right to livelihood. And then within the unenumerated right, we were also clearly looking at right to health in terms of mental health. And then we were looking at within the mental health, we were looking at the rights of the vulnerable by reason of that. And then we were talking about liberty, while judgments came in the line of liberty, liberty as in the freedoms and liberty as in individual liberty vis-a-vis the state action. So a number of cases come here. Now, in this context, if you see vulnerability, law, and justice relations, which is our concept in terms of, I already connected climate change, I'm going to connect this vulnerability. What is this vulnerability? Vulnerability is the province of jurisprudence and law in last 10 years. We have these developments coming up in lead law schools of the world in Emory or in Yale or Australia or Oxford, and more gaining momentum in the European Court of Human Rights in its judgments. So in a way, we have a very simplistic approach with the private and public understanding of rationality, and then looking at social justice in terms of social justice being live in the private sphere and social justice being facilitated or addressed in the public sphere. Now, this kind of liberal way of looking at human vulnerability sometimes creates problems because we have those strict binary connotations, and then within that we see. So there is a kind of amalgamation or fallacy of autonomy or independence, which is really fallacy, because I was also challenging this idea yesterday in one of my classes, where one of our eminent judges spoke about how upper caste mentality is the one which has put this which is the one which needs to be challenged. I mean, it was a very good, very compassionate way of seeing the whole idea of affirmative action. But my difficulty is that can compassion be compromising the rationality? Rationality for me is vulnerability. And that vulnerability sometimes can be caste neutral. It can be class neutral. I will tell you how. That is why what West analyzed as vulnerability, Professor Bakshi in his writing speaks in terms of human suffering, or Buddha spoke about that. So it is in the same discourse that we can identify the argument of vulnerability and the reality of vulnerability. So a little bit I will highlight on that. Vulnerability is a susceptibility to suffering. So if I'm putting susceptibility to suffering in the core, it is cutting across our given divisions of caste, class, gender, etc. It's also giving expression to compounded suffering of some people, because the word vulnus is about the wound or the pain. It is the meaning. And sometimes, you know, it need not be only in the body. It has nothing to do with embodiment of a person alone. It can be beyond embodiment. For example, as a woman, when I see that I am vulnerable, Mary Healy, a scholar, says that I depend on others' cooperation, I become susceptible to suffering because I'm open to these multiple influences. I'm connected to everybody, whether my husband or my children or the expectations that I have to meet as a woman. And then if I'm a woman who is situated socioeconomically in a vulnerable position, then my vulnerability or suffering becomes compounded. And if I'm a woman who is not able to learn, I suffer from learning disability, so my access to public employment and my opportunities, my accommodation become limited. How does the Constitution articulate this? What kind of understanding do judges have about this? So economic, social, psychological, bodily, moral, and institutional, all these need to be viewed when you're looking at susceptibility to harm alongside the historical positioning. Today, the historical positioning has been shaken or moved with the dent that our affirmative action has made, but that is not a stronger dent because multiple disadvantages like rurality, first generation literacy might be there. We don't have any understanding of this. Therefore, what Martha Feynman talks in terms of quality and quantity of resources we possess or command determine our vulnerability. Therefore, if you look at that quality and quantity of resources, are these only material resources? Could these resources be equal for everybody if the governance or if the state's way of adopting the rule of law and adapting its power to the society is going to make it in addressing such vulnerability of different people with opportunity for innovation, opportunity for growth, opportunity for relationship and connectedness, empathy, pleasure, intimacy, social institutions. Therefore, if we are reconceptualizing this beyond our traditional divisions of caste, class, and things like that, probably that's a more productive way of looking at things. That's what the scholars say in the societies which are hugely divided in terms of race and class. Today, we have a lot of science coming into it, and the science showing how vulnerability has a lot to do with the neural process. There is a neural diversity which accounts for this vulnerability. And if you are putting it on that parameter of mental health and mental vulnerability, I think it's only the neutral parameter which can push us into looking at constitutionalism in a more justice-oriented way, while complying with all the 7 elements that we discussed so far. Now, in the Indian context, therefore, the vulnerability cuts across the segments of women, children, other backward castes, scheduled tribe, minority, differently abled, senior citizens, victims of substance abuse, sick, illiterate, unorganized workers, migrants and internally displaced people, people living with HIV/AIDS today, post-COVID impact, or sexual minorities like the transgenders, and the poor in general, which could include human trafficking survivors and others. Now, just a minute, let us think back on that. If we see that, don't you think time has come for us to review constitutionalism and constitutional values and organic way of living with the Constitution? Definitely. And that vulnerability deeply linked to what Sustainable Development Goals said. On the one side, elimination of poverty. On the other side, gender equality, like 7 notes of music. You have to pay interaction and intersectionality between these. We cannot be oblivious to that. And we also have to see one more important facet of Sustainable Development Goal, that decentralizing the economic power, the corporate power. That is where I connect business to that. I will give you, all of you are familiar with that, but I'll just mention 1 or 2 instances. So we know that how the constitutionalism in judicial innovation resulted in the Bandhuva Mukti Morcha case decision, which made a letter written to the Supreme Court to be entertained as the writ petition and ordered the bonded labor to be freed to live with dignity, devoid of exploitation. And public-spirited organizations got the locus standi to sue or to file a writ with reference to those who are suffering, even though they themselves are not suffering. So this kind of judicial innovation, which we call as public interest litigation, is something that is making everyone to look at India in terms of its living constitutionalism. And then the second one is what we see as development and human rights in terms of anticipatory bail, in case of atrocities, the Prithviraj Chauhan decision, which in a way overruled the Subhash Kashinath case regarding 18A of Prevention of Atrocities Act of 1989 versus 438 CRPC, granting bail in a way subject to DYSP rank inquiry, becoming a block to filing the FIR. So Justice Ravindra Bhatt elaborated the idea of how this legislation's intention was to eliminate caste system, and how the caste system cannot be eliminated, or the caste-less society cannot be achieved if the law is not facilitating it. So it's very important that within the framework of the constitutionalism philosophy, it's not achieving constitutionalism's ethos simply by making expedient policies, but making them according to the ethos of the Constitution and forefathers of the Constitution. Once again, what D.D. Basu said in terms of our living heritage, our living identity as a nation with such a vibrant Constitution. Now, I would bring you to other dimensions also. I'll just touch and leave civil liberties in terms of People's Union for Civil Liberties versus Union of India in 2013, which spoke about public distribution systems and corruption and adulteration riding it. And we also had the Asiad case, which all of you know, which was also a public interest litigation, where deplorable labor condition in building the Asiad village, including the child labor, was brought to the limelight. We had Navtej Singh Johar case, which came up in 2016, with which I started my discussion, which spoke about decriminalizing Section 377 of Indian Penal Code, where the whole constitutionalism philosophy was revisited by Justice Deepak Mishra. Now, we have the whole Asmeta series, which are very interesting series, which show us how the way in which environment, human being kind of interaction has been. We also have the Shabarimala case, where, or if you revisit Shabano, or if you revisit Navtej Singh Johar, what you saw was a kind of striking a blow at the core of the principle or practices of discrimination, and strengthening the principle of equality in terms of addressing exclusion, exploitation, and denial. So this is how the vulnerable segment, whether it is a woman of minority or woman of majority community, upper caste or lower caste, the experience of untouchability that she has in entering the places of worship, that is a denial. What kind of impact it has on her self-image or identity? Isn't every woman's identity, or every so-called marginalized caste's identity, a part of the constitutional identity of us as Indians? So in real socializing and social conversion of the meaning of constitutional philosophy, I always keep wondering about the building, the impeding factors. What is blocking us from realizing this kind of constitutional philosophy in our life? So I have tried to reflect on it as original thought. I will share with you. So we have had many writ petitions in the past, which showed the soul of the Constitution, as Dr. Ambedkar said, the right to constitutional remedy. It has shown the vast experiment or judicial innovation, where the courts assumed the sacrosanct duty of acting as the custodians of the Constitution. Now, we saw that I already mentioned the case. We also had the GST levying, which was justified. And then in Shaheen Bagh protest case, Supreme Court said that public spaces cannot be occupied indefinitely for expressing dissent. So restraint and right, restraint and freedom. Constantly, this reinvention of the balance and constitutionalism philosophy is seen in majority of these cases. Now, coming to our experience in terms of business and climate interaction. If you look at the Bhopal Holocaust in 1984, resulting in 16,000 deaths, 50,000 permanent disablements, lawsuits in New York and in India, 470 million out-of-court settlement, they show how we, in the industrialization's wake, we were not so prepared. So meanwhile, we had series of MC Mehta cases, whether it is about trapezium, where Taj's beauty was being faded because of the pollutant industries studding the Yamuna bank, or it is the case of Ganga pollution. It is the case of precautionary principle being applied in order to see that the environment is not damaged, and no amount of money can bring back the damage that is done. Therefore, the polluter pays principle being applied. One most interesting case where directly the idea of development, industrialization, multinational companies interacting with the environment in India in utter indifference to human needs and biodiversity was in the Nyamgiri Hill case, where the international bauxite mining company, the POXO company in Orissa, tried to take over, and the Ministry of Environment and Forests at that time in 2011 tried to defend the rights of these tribals. And finally, the Supreme Court held in favor of the tribals that the alienation of the permission was done without the Gram Sabha permission. So this kind of decentralization principle, which is in the core in terms of empowering people as the having sovereignty over the resources, is something that is seen as a kind of reiteration of the constitutionalism philosophy. Now, the next question is whether understanding these fundamental rights in the aggressive context of globalization and withering away of labor law or dilution, the disconnect between WTO and ILO, the mental health and trauma dimension of work environment with the organizational safety and health, and family-based businesses and death of the property, death on the property of the businesses, and respecting the employees in various organizations. How do you view that? So in 2020, from the policy side, we had the National Business and Human Rights Action Plan in conjunction with the United Nations Ruggie Report or General Assembly Directive. It was called as voluntary guidelines for the business. This word voluntary was removed in the zero draft of 2020. And today there is what we call as access to remedy as one of the pillars, and then protection of these rights and making it mandatory as other pillars. So today businesses have the right to respect, protect, and remedy human rights. So when they acquire the land, when they do the environmental impact assessment, they have to factor in the human factor. So what we see here in terms of later on, you youngsters like this Netflix and information technology. So intermediary guidelines and digital media ethics code, which came in 2021, also tries to look at businesses in terms of looking at constitutional principles of India in what we call as social security, moral order, national security, moral order, decency, public order, decency, morality. So those restraints were again reiterated. They did not block the freedom, but at the same time, they wanted to maneuver the freedom, respecting the constitutionalism. So in a kind of fast check mechanism, spread of fake news, which could shake the foundations of our secure democracy or nationhood or statehood, was also taken into consideration. One of the most disturbing developments has been the farmers' agitation, and reporting about farmers' agitation from the Greta Thunberg toolkit landed a youth from Bangalore, Disha Ravi, in arrest. And then again, the courts came to the rescue, saying that there is no conclusive link to her social media post and the conspiracy in Red Fort violence. So she should not be considered as the enemy of public order, and she was exonerated. Prime Minister Modi gave this very important address during the Foundation Day of National Human Rights Commission, and he spoke about the neat alignment of human rights and governance. And here he highlighted one important principle: safe workplace for women. And he also spoke about work from home in terms of transport, timing, and facility. And he said how there should be human rights protection both at home and work. So these guarantees show that our governance is sensitive to human rights as it has been in the past. But when it came to business, we have had two important cases. One was 2021's Gangtok Municipal Corporation case versus Union of India. And second was Uttar Pradesh Power Transmission Corporation case. In both these cases, which came in 2021, when they were asking for arbitration-based alternative remedy to speed up these infrastructure contracts with the state. In the first one, it was about employee provident fund application, which was not being applied in state of Sikkim because it was an annexed state. It had a special status under Article 371F. So government said that first let the person go to alternative remedy. Similarly, in UP power transmission case, where there was a question of labor cess being levied on the contractor for infrastructure contract, when the arbitration issue came, they said that there is a self-imposed limitation on commercial matters. So this is a bar for the courts to provide any remedy. Now, this kind of self-limitation of the judiciary, which is otherwise independent, and sometimes disproportionate approach we have seen, is a kind of crucial question which searches for freedom between business and guarantees of human rights. So my last part of this discussion is, where is the constitutionalism going? I would like to introduce, first of all, Professor Grimm, this German professor's idea of social state, where state tries to control the individual power, and under the constitutionalism, state's control of individual power is controlled by the constitutionalism. However, with the vast economic power in the private sector and political parties unwilling to be regulated by the constitution, constitutionalism is under threat. Secondly, is this constitutionalism well synchronized to uphold the rule of law and to limit arbitrary action on the part of the state? Answer is, it's very difficult, because there is another theorist who talks about there is a kind of appeal of authoritarianism for those in power. And that comes because they can quickly act, they can make property, they can be participating in the power. So the lure of power, which may make them or empower them or tempt them to jettison constitutionalism and then justify it as public good without proper power of law. So putting power of law in front without touching the constitution for amendment or things like that requires individual leaders to center stage themselves in terms of what we call as rule of law and accountability. And here they can serve constitutionalism in what Günther Frankenberg found in authoritarian constitutionalism. Are we in an era of authoritarian constitutionalism? If you had looked at American president in the past, or Xi Jinping's life-term presidency, or dynastic rule in India, which keeps showing up, sometimes this appeal of authoritarian constitutionalism is a threat to our constitutional guarantees. So I would end my talk saying that D.D. Basu's idea of constitution as a living heritage and identity, the subjective satisfaction of those in power to be objectively reviewed by judiciary in the power of judicial review, in guaranteeing social justice, fraternity, and human dignity needs to be upheld. So whether we as legal students and scholars are applying this, which I said is a mode of rediscovering constitutionalism, I would propose an idea that if constitutionalism were to be a lived experience, it has to translate into a lived experience in social context. So for that, we have to live constitutionalism as value. Do we do that in our law institutions, in our recruitment processes, in our admission processes, in the way we treat our peers and colleagues and students? How do we constitutionalize our families, our organizations, and our interactions? I'm sure that the three issues I've raised, business, human rights, and vulnerability, and within that climate change, would definitely be answered in a fair manner in conjunction with the constitutional philosophy that we have, constitutionalism not being authoritarianism, if we do this soul searching of lived experience of constitutionalism in our daily context. Thank you very much.
Very nicely explained, ma'am.
I'll be happy to take one or two questions because we are overshooting the time, if you permit. Yeah.
Definitely, ma'am. If anybody has any questions, you all can switch on your audio and video and ask, or if you cannot, then you can put it up on chat as well. I think, ma'am, you've been extremely clear and precise with your explanation. And it was indeed a very, very enlightening lecture. And it was very interesting as well to understand the intricacies of this subject. So thank you so much, ma'am. I would now like to request Professor Dr. Umesh Aswar to give the vote of thanks.
Thank you, Ketavin. Very warm good morning to all. I consider it a matter of immense happiness and privilege for having been conferred with an opportunity to present vote of thanks. I, Dr. Umesh Krishnarao Aswar, on behalf of GLC, principal, alumni, professors, students, and entire GLC family extend my deep sense of indebtedness and gratitude to the resource person, Honorable Madam Professor Dr. Shashikala Guppa, Director, SLS Pune, Dean, Faculty of Law, Symbiosis International University. Madam, your contribution in the development of legal system as a member of Law Commission and your contribution as a professor for the development of the legal education, particularly in western part of India, is well known to all of us. I have personally witnessed the way in which you have groomed not only the students, but the junior professors, including myself, and how, as of now, they are functional throughout the state, throughout the country, in different institutions, and they are trying to do their best. Madam, I must take it as an opportunity, and I must reveal that while I was sitting in a governing council with the then Secretary of the Governing Council, Principal Judge R.B. Malik, how you were invited by Justice Dr. Dhananjay Chandrachud Sahib to present a full-fledged scheme that how come the GLC can reinforce its cultural heritage and become an institution of a unique kind of legal education, particularly when it is having a legacy where at some point of time, Dr. Babasaheb Ambedkar acted as the principal of the college. There are any n number of the instances I can quote, and I will quote one more instance, madam, if you kindly permit. The way in which you were invited by then head of the search committee, Justice Radhakrishnan-ji, to attend the interview which were going on college premises only, the interviews for the sake of the appointment of the first Vice Chancellor of MNLU Mumbai, wherein it's a part of a record and I was part of that process, that you declined because of your professional and personal commitments. In a same series of event, madam, today your lecture was so insightful and it was enlightening for us, wherein you have pondered upon the true facet of the constitutionalism, that how at one hand, under that concept, the rule of law is required to be upheld, and at the same time, its content in form of human rights are equally required to be preserved, which will be next to impossible, as you have nicely narrated, picking up these emerging trends like climate change, protection to vulnerable groups, and protection to business class. It will not be possible until and unless it got a base of a morality, inner ethics. In a nice way, madam, you have convinced us that at the end of the day, it will not be a constitution, but if we are able to live with the constitution, inculcating it in the personal life, family life, and then into the society, then only the desired effect is possible to be met up. Hence, madam, once again, on behalf of a GLC family, I'm very thankful that you graced this occasion, you accepted the request, and you delivered such a nice address. Thank you, madam. Moving ahead, I'm equally thankful to the college principal, to whom, when your name was proposed by senior professor of the college, of course, backed by me, senior professor of the college, Professor Dr. Panchbhai sir, she readily accepted it, and she has given us a full free hand to conduct and organize this program. So I'm thankful to the college principal. I'm also thankful to the senior professors of the college, including the adjunct faculties. I'm thankful to the teaching, non-teaching staff, the general secretary of the student council, and the technical team. Without their efforts, silent but active efforts, it was not possible to arrange and materialize this program. So thank you very much to them as well. And I hope that, madam, your blessings and your interaction with this college will continue in future as well. Thank you very much to you.
Thank you for inviting, and I'm blessed to be in the tradition of footsteps of Gandhi, Palkiwala, and others. So it's just an honor. Thank you. I'm humbled. Thank you. So permit me to leave if it is okay. Thank you, Dr. Vaidya, Dr. Umesh, and dear students and the compeer. Thank you.
Madam, for a minute,
Yes.
You can be here. We will have a screenshot.
Yes, ma'am.
And we'll end the program with national anthem.
May I request everyone to please switch on their cameras if possible so that we can quickly take a group photo. Thank you so much. I'll now be sharing the national anthem. So I would request everyone to please rise for the same.
Thank you, madam. Thank you very much.
Thank you, everyone.
Thank you. Bye-bye.
Bye-bye.